attending both in person and online today. In person, just make sure you sign in when you come in to get your in-person credit, and online, please let us know if we're having any technical issues with sound or video or anything during the presentation. We'll try to be responsive to those. Today for our February forum, we have with us Melissa King. She has been with Bowser for 6 years and is currently the Tribal Liaison. She assists or coordinates with Bowser to ensure that their work to facilitate. Sorry, you had an introduction. That's all right. I tried to do it from memory and I couldn't. So she is her role works to cultivate meaningful relationships with tribal nations and tribal organizations. She provides guidance to the agency to ensure that Bowser's work is guided by principles of respect for tribal sovereignty and brings awareness and ensures tribal values and concerns are considered into the agency's initiatives and policy making. So with that, please help us welcome Melissa. You want to share? Let's
I think share screen. You all are seeing the screen online, correct? Or not? Correct. See it.
No, I can.
Now we can.
Now we got it. We're good.
My desktop now.
Mm-hmm.
See if this. Are you seeing the presentation or are you seeing my presenter screen?
We're seeing the desktop.
Connect this, please, and try again. Let's try this. Maybe. Screen two. How about now?
Perfect.
Give it a go. Okay. Speak up because I can't see the WebEx on the screen if there's a lag or something. Maybe help me get a flavor of who's in the physical and the virtual room. Throw your hands up. Or consultants, local governments, and how many Bowser or other state people are on? Okay, we got hands up and down. Sorry, people online, we flew through that really fast. So I'll just give a little thanks for the intro. Thanks for the invitation and for rescheduling. I had a conflict last year. We just appreciate the opportunity to just have an open conversation. We're going to cover a ton of ground. And the way I like to try to do this is open and honest forum. Like, I am not an expert. I don't speak for my tribe. I don't speak for other tribes, but I'm happy to share like my personal work perspective, give you some information. So just as we go along, please raise your hand, shout questions out. You have a question, somebody else probably has a question, and maybe someone is too afraid to stick their hand up and ask it. If we don't make it through all of the content sort of stuff today, like that's okay. That's pretty standard for our conversations inside of the agency. And it's fun to just dive down the rabbit holes that we might go down in some of this. Maybe another show of hands, like how many of you have maybe good working or have worked with tribal staff, tribal governments, kind of in your line of work in the past? So quite a bit of you in the room. How about folks online? All right, we're getting quite a few hand raises and a resounding yes, Kat. I like the enthusiasm coming across. All right, so maybe this might not be super new to you. Think why are we as a state agency? I think talking about it, why I am Bowser's first tribal liaison. So maybe I'll back the bus up a little bit. My background has been in water monitoring, water resources management. I grew up professionally sort of through the ranks of the local government units. I worked for region watershed district for a long time. I went outstate to work for a city. I worked for the Minneapolis Park Board. I worked for Washington Conservation District. So I've kind of bounced around in the course of my career. I have been at Bowser for going on 7 years at this point in a couple of different capacities. And then was hired on full-time into the agency's first tribal liaison role last November. And I've had a portion of my work sort of been reassigned to just figure stuff out, help conversations inside of the agency for a couple of years at this point. If you're not aware, a state law was passed in special session in 2021, basically codifying expectations for state tribal government relationships. And in that law, Minnesota statute 10.65, there are specific state agencies named, of which the Board of Water and Soil Resources was one of them, to basically recognize the unique relationship with tribal nations that are in and share geography with the state, the people that we share, but also to cultivate a meaningful relationship. I'm not going to dive too much sort of into state statute. It's a pretty short read. There are more agencies getting added to that list every year, but for something that's been around a while for the cabinet state agencies, the DNRs, the healths, this has been guided by executive order, actually starting back in Governor Jesse Venturo's administration. So for us as a state agency, it's pretty new, but the expectation has been there for state agencies for quite a while and a lot of good work. So I would say that's why my role was created, to just help these expectations. I think for us in general, you know, like it's not new to Bowser. We work with others to do the conservation work on the ground, and just to have an expectation that we are having conversations with tribal governments in the policies that we're setting and the programs we're developing, to consult with tribes, because what we do also has an impact on tribal water resources, tribal citizens, and tribal governments in the state. Kind of questions maybe on that general overview comments? All right, cool. I'm going to take off. Maybe not. There we go. Just sort of general philosophies. I don't know how many Native folks might have in the room or online, but I'll just give you a little perspective of how I was raised. I am a member of the Odaawaa Band of Lake Superior, Ojibwe, located in northern Wisconsin up by Hayward. I grew up on the reservation. My family is all still on the reservation. And you this saying, water is life, a lot in the last like 5 to 10 years with some of the projects that have maybe risen to media level types of things. The mod to the windy beef. I think in general, like for the way I was taught and the way I was grown up is we have respect for all things living and non-living, plants, animals, people, and everything has a spirit. Like we are not above any other form of life. And we have a real reciprocal relationship. So we take what we need, not more than we need typically, and we provide an offering and a prayer when we go out into the woods to go hunting, to go fishing, to go cut firewood, to go collect medicines, whatever that may look like. So it's really rooted, I think, in just the spiritual relationship with the earth and with things on the earth, but also not just for us. Like you might have heard like the 7 generations teaching in that we're looking backwards and we're also looking forwards, not just trying to protect water, trying to protect resources for us, but for my grandkids, for my kids, and for 7 subsequent generations down the line. And for some tribal governments, like this really philosophy, like is really rooted and embedded in the governance system and just way of life and how to take care of it. So maybe who wants to give this a shot? Generally, what is tribal sovereignty? And if there's anything I would like anybody to walk out of this presentation from is like a really sound understanding of maybe what this is and what it means. Anybody? Yeah.
Along the lines of like self-determination, self-authority.
Yeah. Awesome. And I'm not going to read all these words on all of these slides to you, but tribes have retained their inherent sovereignty to govern themselves, to dictate how to do that, what's best for their governments, what's best for their people. That is not a right that was granted to us as a part of entering into nation-to-nation treaties with the United States government. This is inherent ability that we had all along, an inherent ability that we have retained. And I'll have a video that kind of talks about this a little bit to help maybe cement some of this fact in. A lot of tribes have their own court system. We have our own laws and ordinances. They don't always just apply to tribal members. It makes jurisdiction, which we'll sort of touch on a little bit towards the end of this, like super complicated. And it's not that we chose things to be so complicated. It's just in the inherent web of federal, tribal, state laws that we're kind of working in today. All I can say. So if you're also not aware, there's this period of treaty making, which will really kind of talk about some of the historical acts that have happened, why land is the way that it sort of is today. But over the course of once the U.S. became, the United States, and we have this founding constitution, there was a period of about 100 years where treaty making was happening. The government ratified just over 365 treaties with tribes in what is now the United States. Not all treaties dealt with the cessation of land, giving that land from sort of tribes to the government. Some were for healthcare, some were for education. They're just all widely different and probably not equivalently the same. I want to say there was roughly 25-ish treaties ratified in the area that is now Minnesota today. Not all of them had to deal with ceding land and giving land over and creating reservations, but some were. And if you go to this whytreatiesmatter.org, it's a very Minnesota-specific look at that history. Tons of resources. Take a look at it. When you have time outside of this, there's just a lot of really good historical information that's on that webpage. So this has been a good conversation that we've had at our academy and in the trainings and learning opportunities that we have hosted for our own staff at the agency. Why don't we treat tribes like a government, local government, a state, or an LGU? You can sort of see the map of the landscape of relative to Minnesota, who we're talking about today. I won't put anybody on the spot, but when in doubt, inherent tribal sovereignty. Those of you that are consultants and even some local governments, the state puts on a tribal state relations training. This is a training required by law for state agency staff. They have been inviting more local governments to participate, but it's a training that's hosted by tribes roughly every month around the state to have like this 2-day intensive workshop about why it's important to build meaningful relationships and some of the history we'll talk about today. But a key word coming out of that all the time, the key phrase is, when in doubt, inherent tribal sovereignty. Really, again, tribes predate the United States. They predate the Constitution. Tribes don't derive their authority from the Constitution like states do. And so really at its basic level, tribal governments and tribal nations are not states. The really complicated probably answer to this is there are like a couple centuries worth of court decisions, federal laws, federal policies, the treaties, executive orders, judicial opinions that all meld into sort of the aspects of what tribes can and can't do under some of the course of the law, but just this general broader concept of federal Indian policy, federal Indian. Just breaking it down in background, if you're not familiar, there's the United States Code of Federal Regulations. They have a title that is 2 volumes, Title 25, called Indians. I'm going to use this language a lot because that's just what's in a lot of federal laws. Personally, I don't, outside of Native communities or Native people that I might interact with, I don't prefer to be called an Indian. Like, I'm Anishinaabe, I'm a Ojibwe. It's just kind of this overarching lump, right? Sometimes what we like to do as a country is put people in these broad terms. And so I'm going to talk about that term a lot, but just for everyone's reference, please don't call me an Indian on you. So where I'm going with this is federal law in the code just defines terminology that we're going to cite of. So I would say a lot in Bowser's work in particular, we'll talk about tribal lands. That means probably a lot of different things depending on who you're talking to. So trying to cement today in like defined definitions in federal Indian law, federal Indian policy, and what that means and how Native governments have to operate today. So I'm not going to read it to you. You could go to this code and pick on that, but that defines who a tribe is. And I will distinguish, if you're not familiar, there's federally recognized tribes, 508 across the United States today. There are non-federally recognized tribes. You have to have the federal recognition in order to get the goods, protection, and the services from the United States government. The last time I dug into this, there was some research done in like the 2012 era. There's roughly 400 tribes across the US that don't have federal recognition. Maybe they had it and they had it stripped away because that was and actually still is a thing today that can happen. Or we were lumped, you know, in periods of treaty making as groups of people and maybe were punched in. There are actually non-federally recognized tribes in existence in the state of Minnesota today. Actually, there's a West St. Paul non-federally recognized tribe that just submitted an application to the US government to get that recognition reinstated. They operate in all different capacities. The Middle Marketon community in West St. Paul, they operate as a nonprofit in existence of government. There's Sandy Lake Band of Chippewa up in the north, up by Mille Lacs. They are members of another Ojibwe federally recognized tribe. So just a little background and perspective on that. Who is a quote Indian? There is no singular definition basically in law today that dictates who an Indian is and isn't. And it's more complicated. Each tribe is guided by a constitution, like we are in the United States. That constitution describes the requirements for citizenship. These constitutions were largely developed by federal agencies and employees for tribes, not that tribes develop these constitutions on their own. And I would say a lot are defined by this system that was imposed of blood quantum, right? Like how much of an Indian are you on the basis of blood? And the only equivalents to that are for horses and for dogs. So it's not great, on my personal opinion. And it's an assimilation tool because as we have kids outside of our community and outside of my tribe, you know, under this quantum theory, it's your blood diminishes every time that happens. So you are deemed less of an Indian when that happens. And just sharing my personal story. So my mom is not Native. My husband is not Native. My kids meet the citizenship requirements right now to be considered for enrollment into my tribe, and they are enrolled members. But if they have kids outside of my Odaawaa-Zaaga'iganiing tribal community, my grandkids, if I have any, will not meet the citizenship requirements for my tribe today. Hopefully it changes. Red Lake Nation did an interesting study that I think you can find publicly online. Like there is a definitive time frame where Red Lake determined for its citizens that it will no longer have people and enough people that meet those quantum requirements to exist today. So just to give a little background and perspective on that. And really in terms of federal and other state law, a lot of different programs and different laws that define sort of what an Indian is for the purpose of carrying some of that out. But at the base level, each tribe determines its own citizenship. And I'll just lay this nugget onto of I can't be enrolled in more than one tribe at a time. I'm descendant of St. Croix, which is just across the river over by Turtle Lake. And descendant of White Earth, I can't be enrolled at all three of those at one time. And so for even citizenship, it's a portion of quantum, but who is your lineal direct descendant that was an enrolled member of that tribe at a really particular point in time. So you have to be able to, or at least for my tribe, meet those requirements. So if someone hopped out and was enrolled at St. Croix or enrolled at White Earth, it'll make it really difficult in subsequent generations for people to maybe go back and want to be a member of LCO if that's the case on it. Okay, tribal nations. So this is the number you get told around, and I won't do a stump. There's actually 12 federally recognized tribes that share territory with the state of Minnesota. You see 11 on there because there's 11 individual tribal nations. We have 7 Ojibwe communities roughly central Minnesota to the north, 4 Dakota communities to the south. There is a tribe called the Minnesota Chippewa tribe, and it serves as kind of a centralized government system. So when we were doing this treaty making, some of the goods and services were coming to the tribe, at least for the Ojibwe bands, with the exception of Red Lake, who is not in the Minnesota Chippewa tribe. Those services were going through the Minnesota Chippewa tribe and dispersed out. The reality is today we have fully functioning individual tribal nations, and the structures still exist and still is operation, but the individual bands are governing themselves. MCT is a little different. All of the bands operate under one common constitution. Red Lake Nation has its own constitution. Each of the Dakota communities has its own constitution. Ho-Chunk Nation, you might not know, Winnebago people had a reservation, and I'll show you that on an old map on here back in the day. But effectively, after the US-Dakota Wars, and we moved all of the Dakota people out of the state, the Ho-Chunk also lost their reservations and had their treaties abrogated and were also moved out. So they still have trust lands in southeastern Minnesota today. You can see that on some maps that are on the state of Minnesota website and in the Mintgeo Commons, or that tribal governments data set, even though their centralized government is in Wisconsin today. Lots of information. Anyone have questions? Okay. And before I move on from this, I will say too, you see the term reservations and communities, and we'll talk a little bit more about this a little later. There is a difference, right? So reservations are reserved areas in treaty that were established. So Ojibwe reservations are still in effect. The history is a lot more complicated for Dakota peoples. Their treaties were abrogated, basically, or nullified by the federal government after the US-Dakota Wars. So they do not have treaty reserved lands, although, in common term, we call all these areas reservations. Whereas the reservations for Ojibwe folks are defined in treaty, those boundaries don't ever change, right? Unless you're going to go renegotiate maybe a treaty or some other act of Congress at this point in time. Dakota communities, the extent of their communities are defined by trust lands, the land that they have converted or have put into trust. Their boundaries can and do change. And we'll talk about the land classes in a little more detail too. So generally on tribal nation governance, and you can find a lot more information online about this, but every tribe determines its own governance structure and laws. The structure of all of the tribes back on that previous map are different and they are unique. They all operate under a constitution and bylaws. They enact and enforce tribal laws within their jurisdiction and with their boundaries. Most tribal nations have 2 branches of government. The Lax Band of Ojibwe is a lot structured like the federal government, where they also have an executive branch agency. Who has had some interactions with tribal consortiums? Nobody. This is the thing I like to say. So even though the red dots and the green areas on the map before, all land in Minnesota was tribal land at one point. And so these areas on the map on the right correspond generally to years of treaties. There could be 1 or more treaties in effect for those polygons on that map. Those numbers just represent the year that the treaty was basically ratified and enforced. But all land in Minnesota was outside of what was initially reserved for reservations is ceded territory. And at least for Ojibwe people today, we retained rights in those ceded territories to hunt and harvest and gather. And a lot of that work off reservation is guided by these tribal consortiums. Conservation officers, monitoring and research work, they're regulating where we can harvest, where we can go, how much of what species we can gather. Some things are more, more intensely regulated than others, and some of that is done in cooperation with the states, like for walleye harvesting and for wild rice. Just give an example, the ones that are 2 that you might know about, that's a little different here. So that 1854 treaty area, there is a treaty authority. There are 3 tribes in Minnesota that were originally part of that, Grand Portage, Fort, and Fond du Lac. Fond du Lac currently does not participate in the 1854 treaty authority. Grand Portage and Bois Fort basically work cooperatively in that treaty area to manage resources and hunting, harvesting, and gather. Fond du Lac does their own individual management for their members. I'll share, I think I have a version of the Great Lakes Indian Fish and Wildlife Commission based out of Dana, over by Bad River in Wisconsin. My tribe is a member of that, and we have treaty rights across Minnesota, Wisconsin, and Michigan. So Glyphwick, using their acronym, is our consortium that manages, I want to say like 11 Ojibwe tribes are part of that. Even though there might not be a really formalized established consortium, that big 1855 treaty area, there is a kind of partnership consortium of federally recognized tribes, non-federally recognized tribes that are working to basically get the government to recognize their rights to hunt, harvest, and gather in that particular area. The map on the top left, that's Red Lake Nation. And these treaty areas are arbitrarily cut by the state boundary. The state didn't exist when these treaties were negotiating. And some of that history is the treaties had to be negotiated for the state to join the unionhood. But just showing like these areas extend beyond just kind of current state geographical boundaries that we know today. So things to think about as you're working on wetlands across these areas. And just generally, tribes don't just have an interest in what's happening within reservation boundaries. They might be very focused in those areas because that's where people, right, like reside and live. Centrally, might have a government, but they're inherently interested in ceded territories across the whole area. And those of you might be familiar, there's cultural areas, burials all over the state. Like the Dakota were everywhere in Minnesota before us as the Ojibwe migrated over and started taking up residence. So where you might be working in northern Minnesota, not thinking there might be a Dakota connection, there could be a Dakota connection or a connection to another tribe outside of the state today. So just things to think about. This is at 1855. Just scooch through this. So I'm gonna get away from the mic a little bit. Oh, you don't know, this is our county. This is my reservation, the Green Reservation. So this is just to get emphasis, like all of the treaty areas that Glyphwick is working to manage, that the tribes are working to manage, hunting and harvesting and gathering in. Using my tribal ID, it's good enough. And this is where I tell folks, like, it gets complicated. Like I live in Minnesota. I'm a resident of Minnesota. I'm a citizen of Wisconsin, tribal nation. In theory, I can go up to that 1854 treaty area. I don't need a state license to hunt, harvest, and gather, but I do have to follow the laws and regulations that my tribe and that Glyphwick is setting for me. So I might need to go get a tribal permit or permit from Glyphwick in order to exercise some of those rights within that area. Let me see if I can get this animation to work. This is kind of a neat little video that just shows the cessation of land as treaty making was happening. This is put together by, I can't remember the university that puts it out, but you can find it on YouTube on here, just to give you the visual. So it's kind of interesting. You can sort of see that westward expansion and colonization of the country. You could probably take a guess maybe when the gold rush really hitting off in California. And then today, the extent of just area being occupied. And this is a little bit about that. All right, let me figure out. Here's like a lay, bear with me. All right, so ceded territories, again, it's a treaty created situation. From 1778 and 1871, the United States was developing these relationships with American Indian, well, now as American Indian nations across the area. Nation-to-nation contracts recognize and establish a unique set of rights, benefits, and conditions for treaty making with tribes who agreed to cede millions of acres of their homelands to the U.S. and accept its protection. Treaties, they are considered the supreme law of the land. The treaties are still in effect today, at least for some of us. References in the United States Constitution to Indians at a base terminal of tax references. So some of this is just rooted in kind of the core documents, founding documents for the country as well. The map on the left is kind of the more complicated version of what was happening over on the right. And with this weird little sliver that you see 1858, 1863 with the Upper Sioux community and the Lower Sioux Indian community, that was the extent of their original reservation, 10 miles on either side of the Minnesota River. Scale and difference, there's just, I like this reference. Leech Lake staff shared this out a few times with me. Leech Lake Reservation is just over 900,000 acres. It's the size of Rhode Island. So you're looking at 4 tribes that have roughly 1 million acres within their original reservation areas. Dakota communities are down to around 2,000 acres. So it's just miles in latitude of difference. I am not going to read all these words, but via these treaties, the federal government has a fiduciary trust responsibility to Native people, federally recognized tribes today. It's legally enforceable. You've probably heard of the Bureau of Indian Affairs. They're the state agents or the federal agency that manages a lot of land transactions. They were initially managing annuity payments, goods and services that were promised to Native people as a part of these treaty making, but really every federal agency, much like those of us identified in state law, have a trust responsibility to tribes. That responsibility just does not sit with the Bureau of Indian Affairs. And all this is rooted back to just that responsibility of this first bullet, Chief Justice Marshall. That's what is kind of the founding start of federal Indian law. Started with that Marshall trilogy, and it was cases that went basically to the Supreme Court, and there's some volumes of decisions that have been audited. It's kind of dicey times right now. You're not getting what's happening on the federal level, and a lot of worry, and where things were just really rooted in foundational health, like things are constantly changing. Or attacks on, and we'll talk about Indian as sort of a racial versus kind of political class. That's where I think sometimes you get the question of, well, why do we have to learn about Native people, or why are they so much more important than other groups of factions? And it's not a matter of being important, it's just that the relationship that exists nation to nation between the United States and federally recognized tribes is just inherently different because of these treaties and the treaties that are still in effect today. So if you're familiar of working with tribal leaders, tribal staff, like, yes, we are a racial classification when you get that box, but we are just a distinct political class because of these nation-to-nation treaties. So there have been situations recently that have gone to the Supreme Court, sort of challenging that decision, that kind of Supreme Court viewpoint of Indian as a political class. And it might be coming up again. It could. So it's a really dynamic landscape that were things I thought were really rooted in Supreme Court decisions and previous case law, like, all of that is kind of changing and is very fluid right now. All right, we're going to talk about some of the history, because you're probably wondering of like, oh, those green areas on the maps and whatever. All of that land was originally held in common benefit for a particular tribe and its tribal members. And those of you that are working on this landscape, like, there's a really dynamic, complex web of land ownership within reservations, most of the reservations right now. So we'll sort of lay some groundwork for why is that. And you can sort of get a gist. We're not going to talk about all of these. We just don't have time today, but you can sort of ebb and flow. These are the direction of federal Indian policy, and the direction it's gone from treaty making, removals, assimilation, and we'll probably not get too far into reservation and assimilation. And then there's this big reorganization that happened in the 1930s to try to get tribes on their feet as self-governing, self-determined, maybe more of in line of what we see or what we were used to based on that European model of how our country was founded. We are not going to talk about all of this, but sort of starting with, right, like the United States Constitution. And just a short 2 years after that, the first treaty with the tribe was ratified. Via the Constitution, the United States government was the entity that had the authority to negotiate treaties with tribes. So states do not have that authority even today to be able to do that. A first agreement to acquire land within Minnesota's sort of current boundaries was in 1805. Swap Land Acts, for anybody that's familiar, there's been a number of amendments to the original one, but basically turning land, federal land over to the states that would agree to drain it, to get it settled and to get it farmed. That had a major impact when that act was extended and sort of into Minnesota, particularly in the South, where now you see this rush of settlers coming in, displacing Native people that were on that land to drain wetlands and to cultivate it. Which is probably what it looks like today. Kind of this period of 100 years, and shortly after the U.S.-Dakota War, which we'll talk a little bit more about, 1871, Congress suspended formal treaty making with the tribes. So that was effectively kind of the end of it. Shortly after this, the Indian Removal Act, that was, you probably heard, right, Cherokee with the Trail of Tears. As that westward expansion was happening, settlers increased and were moving westward. The federal government was entering into these treaties with tribes, reservations were being created, and Native people were being moved and relocated onto those reservations. The 1830 Indian Removal Act gave the president authority to give unsettled lands west of the Mississippi to tribes in exchange for land that's further east. And then, right, like that just kept getting pushed up. Kind of some more specific stuff to Minnesota we'll dive into, starting sort of with the Homestead Act, 1862, enacted shortly after the Civil War, often as a boon because it provided a pathway for free slaves to become owners, land owners within this act. And it was really designed to spur development west and economic growth. Under the basis of this act, it was pretty vague. Any adult citizen, intended citizen could claim 160 acres of government land. They were required to live on an improvement for about 5 years. There was a buyout that they could have so that could become fee title owners to that land in a shorter period of time. But once they cultivated it or met these criteria of the act, then it was theirs, fee title. Okay. Under the course of this act, it was in effect, you could still homestead in Alaska until 1986, within there, right? Like the reality is like land did go to individuals, right, that were wanting to sort of have that dream of their own land and become farmers, but it was because there were such loose restrictions within this law, most of the land was being allocated out to logging companies, railroad companies, and kind of these bigger corporations and industries. In my reservation today, there is still a lot of land held by timber companies that do actively forest management on those lands. Of the 500 million acres of land dispersed by the General Land Office between 1862 and 1904, roughly 80 million of that went to actual homesteaders, just for some perspective on it. Sort of why is that important, right? So like in Minnesota, Native people were not, exempt from this. We were being moved onto reservations as well. And this is that map I was sort of talking about that gives you perspective of where the Dakota reservation was at. That little green spot is the Winnebago / Ho-Chunk Nation today, where their reservation was at on there. And really they were moved onto a land area that could not sustain them. There wasn't enough area to hunt. There wasn't enough food to hunt and gather. People were starving. The government was withholding payments and rations, and people were starving. Go ahead.
Can you describe the nuance between Sioux and Dakota, the naming?
I would say from what I have heard in my interactions with staff and people, like Sioux is what the government called us. Like Chippewa is what the government called us Ojibwe people. I would say like their names today have it in the title. Those were names given to them, not names that we were chosen amongst themselves. So this is a good question of everybody's different. Has different ways that they identify and ask themselves. If you're in these interactions with tribal staff and tribal people, just ask. But I would say by and large, what I have experienced in this landscape is that's not a preferred term to be called. Yeah, good question. Thanks for asking. The US Dakota War, there is kind of a cool interactive website to give you a lot of that history to work through some interactive things, but basically in retaliation of what has amounted to some folks going and stealing some eggs that led to just a lot of conflict between settlers in the area and the native population. The US Dakota War was probably maybe one of the shorter ones that we've experienced, and that ultimately surmised in the Dakota having their treaties abrogated by the federal government. They were exiled from the state, and 392 Dakota prisoners were tried and to be executed, which led to the Dakota 38, I think today, that ultimately didn't get pardoned from that. There's a lot of really sad history. This is where it just gets complicated with rights within ceded territories, right? United States exits treaties all the time, even today. But with Dakota people, the treaty wasn't in effect. They didn't get a reservation. They didn't get their lands back, and they got exiled. I have not heard anything about them trying to pursue, like they still retain rights in Dakota territories to hunt, harvest, and gather. Whereas, right, like Anishinaabe still have treaties today that effectively guarantee us our rights to be able to do that. So it's just, when you get to talking about treaty rights, ceded territories in the southern part of the state, like it is just a lot more complicated. And this is just kind of a fact that weighs not through when we talk about this. The same year that the Dakota 38 were tried and ultimately largest mass execution in the United States, like this was the same year that slaves were emancipated. Like there were good things happening for folks, and there were not great things happening for folks across the landscape. So I give this scale today, at least at the time that I put this together. Like you can see the fraction of interest even from Dakota reservations from back in the day to here's the extent of the Lower Sioux Indian community today. So just some perspective to look to that. And then this is, I don't know, I use neat in a weird term maybe, and the same, just a map of like, I think when we think of Indian relocation, that's what I went to public school outside of my reservation, and I learned about the Cherokee. I didn't learn about my tribe's own history. I didn't learn about Wisconsin, Minnesota history. But for some, I don't know why this sticks in my brain, but for like one week period in 5th grade, we read about the Trail of Tears and had to do a report about that. So this just puts perspective of the displacement of the Dakota people across that area. So just kind of an interesting map to maybe put it more in terms of our local perspective. Okay. So these are some elements that are specific. And so like this allotment act was sort of the kickoff, right? Like surplus lands were being sold. The government was selling surplus lands. We have Native communities on reservations right now. And then we see this series of policies and laws being adopted and enacted to break up that cohesion of Native nations, families, and break up that cohesion of land within reservations today. So we talk about the Treaty of 1867, didn't quite come to fruition because we still have reservations and Ojibwe people independently across Minnesota. But the purpose of this treaty was to try to consolidate those reservations and move all of the Ojibwe people into a common area, sort of by White Earth and Leech Lake today. We start seeing these acts, other treaties and acts coming to play, and we'll talk about the Dawes Act to break up that land within the reservation boundaries. So why is Red Lake different than the other Anishinaabe bands? Red Lake is one of 2 federally recognized tribes today, but I don't know how, like master negotiators or just held some ground when others were not able to say no or where no wasn't accepted. Lake is only one of 2 tribes left in the nation where all of the land within the reservation is still held in common for the benefit of the tribe. And we have some maps later in this presentation that will just show now we have this checkerboarding of land ownership happening by these treaties, because these land areas within reservations are now starting to get broke up. And we see these allotments coming into areas. So individual band members could get an allotment, their quarter section of land under this treaty, 160 acres. I don't know why like these 40, 80, 160s increments are always these magic numbers that surveyors use and leaded. The crux on this one is that they had to cultivate it at 10 acres at a time. Once you did the first 40 in cultivation, then you would get your next 40. Like, I don't know how many people under this particular law were able to actually get their 60. I mean, maybe a little different with technologies today. Like, my tribe's land's pretty rocky, like great for farming. Like when you go into northern Minnesota, right? Like how much farming would you have seen back in this day, or like people realistically trying to make its way through? This is where the breed mixed blood kind of quantum requirements come into play, and I'm using that because that's like actual language in these treaties. It just gives you a perception of how we were viewed, and just how this kind of stuff created division maybe amongst tribal members in a community there. They could not receive their duties in this form, except for those that actually lived with their people on one of the reservations. So, right, we didn't stay stagnant, as at least I can speak for Ojibwe. We moved around a little bit, follow the resources, follow the animals, follow some of the land, maybe to do some trading business, to get together as social events, at powwows, ceremonies, like all of the stuff that's going on. Land couldn't be transferred to any person not a member of the Chippewa tribe, which actually maybe was a good thing, because then it wasn't coming out of tribal sort of ownership. But then that changed in 1904 by this particular act, which allowed that land to be sold and transferred to non-tribal members. And at least under this treaty, the compensation proceeding roughly 2 million acres, equivalent of like $145,000 in goods and services that probably never actually made its way to the tribal members, the tribal people living in these areas. The Dawes Act, this is the huge one. So we have homesteading happening, that westward expansion happening, Native people moving onto reservations, and this act in particular was super critical at breaking up those land areas within reservation, with the practice to disrupt that cohesion sort of family unit and to assimilate Native Americans into mainstream society. We want you to become like the settlers, settle down and start farming. Again, we sort of see this head of each family allotted 160 acres, a single person 80 acres. This is where this registration on tribal roles comes into play, sort of these census documents of where you were a member of, not, right, like multiple communities. So with this one, right, like you probably only having so many members or citizens being dedicated to a tribe. Once all of those allotments were had, all of the surplus land within a reservation was then taken by the government and sold for auction, which is, this act is critical to why we see land, kind of the variation of land ownerships within reservations today. Another one of this is kind of trust land is sort of in perpetuity today. There is a process that tribes and tribal members have to go to put land into trust. It's not automatically in that trust status. This one had a life expectancy on it. So at the end of that 25 years, that land came out of trust and was taxable at that particular point in time. And then again, tribal land's not allotted and sold, or open mostly to non-native settlers, and probably forest timber companies, railroad companies for sale. So this is a really good also example happening today on the Leech Lake Reservation. This is an older map. They did have a transfer of land back from the National Forest into them, but it just shows you in an area the size of Rhode Island, roughly half of it is water within the reservation. The tribe today and the Minnesota Ojibwe tribe today retain ownership or trust land status of about 9% of land within the reservation. Grand Portage has bought back, worked with nonprofits to buy and to transfer back. Grand Portage is probably the only other tribe in the state. They have just over 98% of the land, and Grand Portage is in trust for the tribe. Most of us in Wisconsin and most folks in Minnesota, we're probably in that 9 to 12-ish% range, give or take. So we have Jobs Act coming in, we have the Homestead Act happening, now we have this Nelson Act happening. Like when you go to Leech Lake, right? Like there are still, where am I thinking? The Mississippi Headwaters. What's the state park that's there now? Right? Has like the oldest pine trees left in Minnesota that were never cut down. Or where was all the valuable timber on Leech Lake Reservation, right? Like in this white pine, what's happening. These were acts to get access to the timber-rich pine lands where now tribal members are getting their allotments of non-pine lands. So it's just like all of these policies and laws enacted to continually break up and get at those valuable sort of resources that were viewed at that time. And then again, tribal lands that were not allotted went up for sale, surplus lands for sale. That's a part of that. And this is just another aspect of, so now we have tribal members getting their individual allotments of land. And then we have this kind of stuff that's going on with the Burke Act. The Secretary of Interior, this is for the Bureau of Indian Affairs, was given the decision to determine whether a Native person was competent to manage their own land. That's a decision that position could make with or without that tribal member's knowledge or their consent. Basically, if they were deemed competent to manage their land, that land was taken out of trust status, then became taxable. But if you don't know what you don't know, it just resulted in a lot of land loss being too taxable for sure on it. We're not getting too much into heirs of allotments and just the complex land ownership where you might have multiple people that own an interest in a particular allotment of land, which is a very real thing today stemming from a lot of this. The secretary could sell allotments of deceased Indian owners, and their heirs to those allotments were deemed incompetent. Again, it's just a way to sort of get at the land access within the reservations themselves. So as a result of Burke Act, you know, just a scale of the amount of land we're talking about, 27 million acres of lands within reservations were then lost out of tribal ownership and control at that time. This is a lot, so it's a good break touch point. Is sort of all of this sort of resonating with why we see this like real diversity of ownership within most reservations today. Does anybody have any questions or comments generally about it? All right, I'm probably running low on time, so we just might fly through some of this next stuff. When you use the term Indian country, I heard it all this growing up. I didn't know it actually meant something real specific in federal law. I like to use this term instead of tribal lands because when we talk like tribal lands as a state agency, we're thinking about who's the owner of that really specific parcel versus this broader definition that is in federal law. When you go onto a reservation into a Dakota community, you're sort of stepping out of the state of Minnesota and into a new country. And at that time, treaty making, and at the time these laws were enacted, those were different sovereigns, right? We have 11 individual sovereigns across the state today. All land within, and this is one I'm going to read to you, sorry, but you can read along as we go. All land within the exterior boundaries of a reservation, and that sort of phrase always throws people for a loop. So why don't you just say all land in the boundary of a reservation? A lot of federal policies and laws are enacted to what's within the exterior boundaries of that particular reservation, including rights of way. is considered Indian country. Dependent Indian communities within the borders of the US. It's relevant for Minnesota, right? Like Dakota people don't have treaty created and treaty preserved lands today. They would fit the definition of dependent Indian communities within that. And there are still this thing of, at the time treaty making was happening, we had reservations, and then the federal government was allotting land to individual Indians. Allotments still exist today. You could have, like I said, multiple heirs and multiple owners on existing allotments. Those allotted lands can be within or outside of the reservation currently. So just land map on the left, again, that's Leech Lake Reservation. The one on the right's a little harder to see. This is the Fond du Lac Reservation within it. So, and again, federal, keep hitting on this because I really want you to walk away with the whys. A federal Indian policy prior to 1870 was dominated by treaty making, removing Indians off that land, creating reservations, moving Native people onto reservations, and inherent conflict that was happening as part of that. And we sort of see this new era of policy happening from the 1870s to 1900, focused on breaking up the tribal community in areas within the reservation. And that was a very explicit goal of the Dawes Act, was this assimilation of Native people into society on it. And to get us to farm, ranch, like homesteaders were doing at that particular time. Red Lake Reservation, when you start looking at their maps, they're different, right? Like you don't see this breakup of patterns. And again, one of the reasons why Red Lake Nation is so unique, why they are a close reservation, in principle, was because again, all of that land in their boundaries, they were not subject to the Dawes Act and the Allotment Act in the same way. A lot of tribes have programs to try to buy back lands in an attempt to make themselves whole again. My tribe does that with forest timber, basically timber management resources. That's not right, like an endless pool of funds to have to do that. And they're competing on the open market with everybody else. A number of tribes have land outside of reservations, but like it's a good one too. So they were not subject to allotment. All of this is considered part of their reservation. And I think they have in that Northwest, like 90% land in that area is held in common for them. You all might be a little more familiar with, like, when we say tribal lands, that might mean something to us as regulators, as state agencies. Like I said, tribal lands, if I already hear this name, people, I'm thinking Indian country. I'm not thinking individual parcel, because all of that area within the reservation was set up for the benefit of the tribes. The tribes are still an authority over that area, whether they own it or not. That is super important in terms of regulatory programs in the state. There are lots of different types of classifications and lots of different types of land areas that tribes and tribal members can and do own. You can't just look at that GIS data set, the personal information, who's the owner. A lot of trust land is going to say, like, in trust of the United States, or something along a version of those lines. Tribes and tribal members own fee land all over the place, and it might not be readily apparent just by looking at what you might assume a name means in the parcel data GIS. And again, I won't reiterate this, but this is just going of territory dependent Indian communities. Those red dots on the map for the Dakota communities, that is still considered Indian country, even if it's not part of a reservation. I will maybe get Alyssa this link to listen to. I'm going to blow this computer up, I think, if I try to play an audio. But we had a lot of good conversations as staff at Bowser about, I don't know why, as state agencies, we like stakeholders as a term. And that's really not appropriate with the relationship nation to nation that tribes have with the United States government, and subsequently that we have as a state of Minnesota with each tribe in itself. This just really puts it in the terms of stakeholders. We think lake associations, potential partnerships, and this guy does a really nice, simple job of laying it out there of does your lake association create laws? Does your lake association have a judicial system in place? No. The inherent relationship is just different in a matter of respect for sovereignty. That relationship should just be different than doing it. And just again, distinct political, distinct governmental entities that you're working with. Leading into this, so I'll hit on these points a little bit with what Minnesota isn't, like our state is not party to the 1837 treaty, right? Like the federal government, again, has that nation to nation relationship with each federally recognized tribe. Constitution vested that the legislative branch has the plenary power of Indian affairs. States have no authority over tribal governments unless explicitly authorized by the United States Congress. And I'll talk about situations where that has happened. Federally recognized tribes were not subordinate to states, and they can have and do have government to government relationships with states. They have intergovernmental relationships with municipalities, with conservation districts, with watershed districts, although, right, like current state today, that might be really variable, the extent of those relationships today. They possess the right and authority to regulate activities on their land independent of state government. There's tribal laws, tribal ordinances, and we'll talk about delegated federal authorities that tribes in Minnesota do have today. That gives them ability, and there is case law supporting their ability to also regulate not just their tribal members, but to regulate non-tribal members in these areas. And they collaborate and cooperate all the time, like compacting with the state of Minnesota happens. There's tax agreements between most of the tribes in the state of Minnesota to collect sales tax. The purchases made on reservation today. They're working through compacting around cannabis right now and tax revenues between both the tribes and the state on this kind of stuff today. So it's all ongoing. There's co-management agreements that happen a lot between federal agencies and the federal government and tribes. There was a co-management agreement recently executed with the Leech Lake Band and the National Forest to be able to cooperatively manage together. And maybe I don't know of an agreement that the state of Minnesota has specifically to do some of this, but I could suspect like maybe it gets to that point in my lifetime, possibly. This just ends to the dynamic of, this has been, like I said, good conversation we've had with our staff of like things people didn't really think about before that, right? Like, does this Wetland Conservation Act apply in reservation boundaries? Does the riparian buffer law apply in reservation boundaries? What are the situations in which that might be the case? It might not be the only law that applies. And so we'll just kind of talk about maybe like things to think about as you are doing work, specifically in Indian country, but other considerations when even you're working in ceded territories and other areas outside of that. And the answer is like, this is not black and white. There is no clear-cut answer to state law applies in only these situations. And that's a really unsatisfactory answer to have. But again, the dynamic of a lot of this history that we talked about plays a role and it's living and playing out today. So when you think about like, does XYZ state law, does shoreland rules, like apply to these scenarios to just get people thinking like, what was the action at hand? Are we talking a criminal regulatory law, a civil regulatory law? Who's got the authority to do that? Is it one entity? Is it concurrent jurisdiction? What is that? Was it a member? Non-tribal member? Was it a member? And we can talk about a couple scenarios if we have time. Like, if I go into, let's say, Prairie Island Indian community and I commit a crime, I'm not doing that, but just throw that out. Like, whose authority do I fall under as a citizen of another tribal nation? Just all of that matters in the complex of how law applies. Who was potentially impacted? I would say this comes into play a lot with criminal regulatory laws of, was it a non-tribal member that assaulted a tribal member? Was it a tribal member that assaulted a non-tribal member? And where did that action sort of take place? All of that is relevant matters. And even complicated further, we'll sort of define what this public law 280 means. Minnesota is a public law 280 state. We are one of 6 states that have that, but even that is different on certain reservations and in certain communities. So this just goes to show, and this will come into play when we talk about public law 280. What types of laws? I think a lot of buffer, a lot of wetland laws. I don't know that I'm even quite clear of like, typically a civil regulatory law, environmental laws tend to be civil regulatory. Maybe it has a criminal penalty associated with it versus when we think criminal regulatory law, like these are the baddie things. I don't like to say, but murder and terrible things that might be happening on the landscape versus like seatbelt violations to the right. Public Law 280, which is, you'll hear that a lot in terms of Indian country. Public Law 83-280 was enacted by Congress in 1953. It was a way to sort of get at this complex checkerboarded ownership pattern within Indian country. And what it did was Congress granted certain states, 6 of us, criminal jurisdiction over criminal regulatory matters within Indian country, acts committed Indian country against Indians to allow that litigation to happen by the states under tribal or federal court actions on it. This law did not grant the state of Minnesota the authority to regulate civil regulatory crimes within Indian country. It did not affect the sovereignty or status of federally recognized tribes. And there have been amendments in case law testing this matter of who's got like some of this jurisdiction with it. The exception of this is one, when the law was enacted, Red Lake Nation was exempt from the law. There were amendments to the law that happened that allowed the state to retrocede its jurisdiction in Indian country, and the state of Minnesota did do that in Bois Forte. So on the Bois Forte Reservation and on Red Lake Nation's reservation, the state does not have authority to regulate criminal regulatory crimes within those boundaries. It's going to fall under tribal law, or it's going to fall under federal law. So Levi Brown, if you ever get the chance to hear him speak, he's the director of tribal affairs for the Minnesota Department of Transportation. He always uses this example of like, if I drive to Bois Forte, what am I going to see on the side of their squad cars? Bureau of Indian Affairs, police enforcement. If I go to Red Lake Nation, what am I seeing on the side of their squad cars? Red Lake Nation, tribal enforcement. So all of this kind of matters in the complex jurisdictional aspects. There's a cool spreadsheet or a cool fact sheet that you can find pretty readily available on the web that talks about this Law and Order Act. Basically allowed tribes with reservations in public law 280 states like Minnesota to apply for concurrent federal jurisdiction. So where the state has criminal regulatory authority now in reservations outside of Bois Forte and outside of Red Lake, this would allow a tribe a pathway to also get that jurisdictional authority. So maybe that's shared now with the state of Minnesota. That is the case when you go to White Earth Nation, when you go to Mille Lacs Band of Ojibwe, they have concurrent jurisdiction with the state over criminal regulatory crimes. So that's why some of this matters, because it's not black and white. And there could be just a lot of concurrent shared jurisdiction and things you should think about in terms of like, does state law apply? Well, what's the extent of the law? Again, am I a tribal member? So I tell people like, I grew up on my reservation. My parents have fee land in the reservation. We have an allotment that we lease from the tribe that my home and my parents' home is on. The county does not have the authority to come in that reservation because we are members of the tribe, right, to start enforcing zoning laws and restrictions. First and foremost, I am a subject to, well, the United States Constitution, so federal law, but I also come under jurisdiction with my tribe. So it sort of just depends like who I am. That same doesn't apply if I were to go to Prairie Island Indian Community. Well, that's probably not a good example. Let's use Leech Lake because it's open and there is a complication of land ownership. If I bought land in Leech Lake Reservation, does Leech Lake tribe have regulatory authority if I want to go build a garage, build a house? No, that would be subject to county, municipal zoning laws within that. I'm not a member of the Leech Lake Band, so it wouldn't fall necessarily under that. But, the asterisk on it, just like the states can do, the tribes can go get delegation of a federal permit program. And there are tribes that have done that. So under Clean Water Act, there's a pathway for tribes to get federally approved water quality standards, which is the case when you go to Fond du Lac and you go to Bois Forte. Pathways to assume responsibility for these programs. Like there's a lot of steps and hoops that a tribe has to demonstrate it has capacity to carry this stuff out on a number of things. And at the time I put this together, you can find this readily available online. Here's the tribes and here's where they have delegated treatment as a sovereign, treatment as a state status under what particular programs. So putting it in wetland words, when you go into Fond du Lac, for example, you're going to need an Army Corps permit. PCA is not doing those 401 certifications on those permits in Indian country. PCA and the state of Minnesota don't have authority from the feds to regulate that aspect in Indian country. Fond du Lac has assumed and has been delegated that permit. So Fond du Lac is actually doing the 401 permit certifications. Fond du Lac. Same thing with Grand Portage. Grand Portage has to sign off that these actions and acts won't also impact their water quality standards. And that's a real thing, right? And the thing that's playing out today is the state of Minnesota doing enough to protect waters. A lot of tribes have standards and laws that can be more strict than the state of Minnesota can in that aspect. So it's just, again, things to think about as you're doing your work. This is just an example. Leech Lake actually had a draft, posted a public comment period and draft on their water quality standards. I don't think it's been federally approved yet, but they're on that pathway to have federally approved standards and subsequent laws and tribal ordinances that would also affect the activities of non-tribal members within the Leech Lake Reservation. So a couple of takeaways, right? Sovereignty, I hope everyone's getting it. Tribes retain the power to exercise like their own laws, their own authorities, civil regulatory crimes in Indian country. Every tribe is different. Not one is going to be the same, look the same, and carry out governance in the same way. Congress has the power to apply any law in Indian country. A couple of asterisks there is like it can't violate the Constitution, and it can't be related to sort of this trust obligation and responsibility that the government has to tribes. And it is possible, and more than likely, especially when we talk water laws, natural resources laws, that there's probably a likely shared and concurrent jurisdiction happening where, and this is coming up, I think, with conversations we're having as a state agency on our rulemaking aspects with wetlands of what happens when we have tribes that have more stringent standards for wetlands within the area. Good question. Like we're trying to have conversations about it. And I think that's where an element of just really encourage you to go, like also doesn't have to be focused on state has the ultimate jurisdiction or the tribe has the ultimate jurisdiction. Like we're all here just trying to also protect water and resources within the realms and authorities that we have in our respective laws and ordinances. So it's just maybe also just not focus on this, who's got the underlying question versus what, can we start a conversation going about what are we trying to do? What are maybe some common goals and benefits that we might share and have? Generally, like there's a lot of case law supporting the extent of tribal authority and jurisdiction. By and large, tribes' powers do not extend to activities on non-members, except, this is where you get a lot of these asterisks. This Montana test is kind of the case law today to demonstrate if a tribe has ability to regulate non-tribal members, particularly from environmental water stuff. The two things have to be satisfied to demonstrate that a tribe does have that ability to regulate non-tribal members. They have a consensual relationship, tribe and tribal members. Do they work together? Do they have contractual agreements? Does the conduct of that non-member on fee land within a reservation threaten or affect their integrity, economic security, health, and welfare, which natural resources do fall under this. So again, it's not a matter of maybe who's got one or the other. You can just be cooperative, right? Like if there's work happening within a reservation, you're working on a delineation in a reservation is just things to be mindful of. Like there's probably tribal laws that might also apply to those scenarios. And maybe if the folks you're working for or the districts or responsible government units you represent don't have a good working relationship with tribal staff, like just make that ask. Like we are people all trying to do the same, similar, same thing. Get to know them, ask them for coffee. You might have a really hard time getting a foot in the door. And that's been my experience of coming from a community outside of Minnesota. They're getting, tribal staff are getting lots of ask and door knocks, information, conversation, but keep showing up because you don't get a response by email. Like these folks are getting flooded by emails. There's typically, most tribes don't have huge, right, like agencies of staff working on things. They do a lot with people in Dakota communities, like Upper Sioux community has one person, one environmental services director that does it all for the tribe. Lower Sioux community, they have 2 individuals trying to do all of that natural resources work. So keep trying. Don't take no response as not an interest. It just might not risen to the priority level at that particular time. Now I'd say as we are getting a better relationship established with each of the tribal governments, and as they are learning more about the work that BWSR does, we do get questions. We've had folks field me of like, hey, there's this mining. There was one kind of in the Minnesota River Basin where someone wanted to do some excavation or open a pit along the river valley. And so they just reached out like, what do I need to do? Like, they can't be experts in all the federal tribal laws and all of the state laws. So it's just a way to work together to be transparent with information and be honest. Like, honesty goes a long way in conversations and things. And again, just acknowledge sovereignty. Tribes possess the powers of self-government, right to form their own governments, make and enforce laws, determine citizenship, do a whole lot of other things. States have no authority over what a tribe does and doesn't do unless that's explicitly authorized by Congress. And you saw that in that example of that Public Law 280 of the grant of criminal regulatory authority in certain reservations within the state of Minnesota today. But again, the state has a government to government relationship with tribal nations, and by such, so do we. And maybe it's not defined in a state law for local government, special purpose units of government. It's just, you can, right? Like, you don't need someone or a law telling you have to do this, but it's just good cooperative work, right? To work together, which I think is not uncommon for a lot of us in this field. So that was a whole ton of information. Thanks for your patience and for being here today. Here's my contact information. If you think of anything after that, like, feel free to reach out. I'm happy, like I said, to field questions, meet up for coffee, whatever, chat about stuff. And with that, I guess any questions or comments that anybody has? Anything online at all this number? It's a good question, but I can't see it. Not that I see it. Okay.
All right, well, thank you. That was a lot of important and interesting information on both the history of tribal relations and its current status with political authority. I learned a lot. Yeah, unless anyone else has any other questions, let's once again maybe give a round of applause to Melissa for her presentation. Thank you.
And these are just some resources. Hopefully folks online can still see this. There's a ton. So MnDOT actually coordinates the state tribal relations training that I was talking about. Those of you that work with our partners and for our partners, there is a pathway for you to get into this training. And I will say, like, it's super impactful. Personally attending it, I go every month when we have staff and hearing the feedback from staff that have gone. It's a 2-day sort of immersive training where you're hearing people that have served as judges, as professors. You get to have a panel of elected tribal leadership, of tribal elders and tribal staff. Try to get into that. The crux is there's a registration form on this page. As an external attendee, you just need to put that you work with BWSR. If you don't put that you work with BWSR and they see you outside of the state system, your application into that will not make it through. And we are seeing more watershed district staff, watershed district managers, others try to get into this. We have done stuff at BWSR Academy. You will never be able to replicate the experience that you get out of this training. So I can't recommend it highly enough. And there's tons and tons of resources. MnDOT does a bunch of lunch and learns with their staff that they let anybody come into. They put their recordings online. So there's a lot of credible things you can find nowadays online, and check it out when you got time.
Great, thank you. All right, and that completes our February forum. Just a few quick WPA updates. We are currently working on our 2025 forum schedule and field trip, so keep an eye out for that. Anything interesting you see going on, certainly reach out to us, let us know if there's anything else you want to hear about, any other presentations, any areas you want to tour. So you could always just reach out to our website and let us know about that. We had a lot of positive response from our January symposium. We're hoping that we can do it again next year. Please fill out that post survey that we sent out if you have any thoughts on how we can improve it or any topics you'd like to see in the future. And I'll just wrap it up with a little reminder that to renew your membership for 2025 if you haven't already. All right, thanks everyone.